Hello, everyone. My name is Tim Pohlmann. I will be holding today's lecture, and I will also start directly very sharply now. It would be great just from experience if you guys could give me a short feedback in the F&A chat window if you can hear me loud and clearly, just to make sure you understand what I say. So I can get started. Very good. Thanks for that feedback, guys. Also, please feel free to use the chat box for any questions. I will try to keep looking at it just to see if you have any questions about what I say. So this should be really interactive, and I'll try to make it really, I want to answer directly. I don't think it makes sense to wait until the very end. Also, for you to know, this one is recording right now, so you will get the recorded session or the recorded lecture right after we end this. So in case you want to go back at some point, or you have to leave early today, don't worry about it. We got it covered. Great. So this lecture today is about standard essential patents as part of your IP management course. To get started, maybe I'll tell you a bit about myself and why you have to listen to me today. So I myself have been to the Technical University of Berlin. I did my PhD there starting in 2009, which was about data on patents and standards. That's really how I got introduced also into the topic back then. After I ended my PhD and my postdoctoral research in 2009, 2010, I went off to start a business from this, which now is IPlytics. I am still in that field of business now, but of course more in the business sense, selling data and analytics to large corporations and not working for the university anymore. However, I still do this lecture, I still write papers, I do still a little bit of research in the areas of economic research on patents and standards. And that is why you have to listen to me today, and I will hold this lecture. What is on our agenda today is we will talk about what actually a standard essential patent is. We have to start with the basics here for those of you who have never heard about it. We will also look at a little bit more deeper into actual prosecution of standard essential patents. How is our companies actually filing those patents very strategically? We will also look into connectivity standards and trends around standards and patents. Where do standard essential patents matter? We will look at how the licensing and the patent pooling of standard essential patents will work. And also I will tell you a little bit about famous industry anecdotes from the world of SEPs. There's a lot of things happening or have happened in the past, I think, that are very famous cases that a lot of people are not really realizing that these cases are about standard essential patents. And of course, I will give you a little bit of an outlook of the future of SEPs and how and everything you need to know to wrap it up. Well, let's get started and see, what is a standard essential patent? And I really start with the basics here because it's interesting to look really at the definition. So if you wonder what a standard essential patent is, the definition you would typically find is a standard essential patent is a patent that claims an invention that must be used to comply with a technical standard, right? So that is the general definition. So a patent, a normal patent that you file with any office where that particular claim is used when implementing a standard, right? To make it clear what it means. In more legal technical terms, the SEP definition is an SEP is a patent that has at least one independent claim, which each element can be mapped on the standard specification. So that is how a patent attorney would, language it. Again, the reason why they put it in different words is it's really important. A claim, if you think about a patent document, a patent has different claims, meaning where it really defines what the invention here, what is protected. And we talk about elements here. And if you find that particular element in a standard, that means any standard that you implement will also use that claimed invention in the patent. Now we'll talk about this in a few minutes, what that means. Visually, it is like this. You know, if you look at a patent document, you have claim 1, claim 2, claim 3. And let's say claim 1 is the essential claim to a standard. We find that claim language, the element description, somewhere in a standard document. And a standard document, similar to a patent, is a technical form of text that specifies a technology. In this example here, 5G. How do I transmit points of data from my smartphone, let's say, to a base station? How is that technology-wise used or solved? It's very specified exactly, because my Apple phone must work the same as the Samsung phone or the LG phone. They all comply with the same standard, the same 5G technology. So specification of how it works is important. And if that touches a patent, we call it a standard essential patent. Why is the world of patents and standards, why could that be a conflict, right? And if you look, again, very basic, what is a patent as a definition? A patent is an exclusive right given by a state for a limited period of time to give someone a monopoly on an invention, right? So you own, as the owner of the patent, you own the invention exclusively, you own it. No one else, right? That's what a patent is for. So it's really about excluding others from using your patented invention, right? It's about exclusion. What is a standard? A standard is a common platform or specification of a technology to connect, communicate, and work on a common basis. So here the main intent is to encourage the spread and use of the technology. And that really, those two definitions, you know, put next to each other, show you how different patents and standards work. A patent excludes others from using a technology. A standard enables the common usage. Everyone is using 5G, right? Not only the smartphones, in the future, it will be also your refrigerator, your smart TV, the car. All products in the market, when they are interconnected, will connect through a standard. And it's a very same technology, and everyone is using it because it's standardized. While the patent wants to exclude, you know, third parties from using a company-owned invention. So how do these two go together is a big question, right? And I'll come to the answer in a second. However, another thing which is interesting to look at is that the TU Berlin did a survey, and they asked the companies in the market about their motives to patent and their motives to standardize. And the main motive to patent, similar to the definition, is excluding others from using their invention, differentiation in the market, freedom to operate, meaning they want to secure a certain market with patents to operate in that market. If you look and ask those companies, their motives to standardize is they want to have a technology that works for everyone, that allows communication, working on a common basis, encourage the spread and wide implementation. So again, also the motives to standardize are very contradictory to the motives to patent, right? Again, patent securing exclusive technology, while standard setting is all about sharing technology on a common basis, the spread and adoption of a technology, so that all the devices can work together, and have increasing usage and increasing actually value to the customer. How is it solved, right? If a patent is a standard essential patent, which means, again, coming back to that definition, you're using that standard and the standard is protected by a patent, the patent owner must allow a so-called mandatory license. And that mandatory license is capped under FRAND. In other words, let's say a company like Ericsson owns patents on 5G. Ericsson must allow access to those patents, even though a patent by definition is an exclusive right. When a patent touches a standard and is a standard essential patent, the owner must make that technology available, and also the patented technology available. However, of course, they can ask for money, right? It's not for free. It's not royalty free, as we would call it. But that is capped. So the license fee, the royalty fee is capped, what people call FRAND. Yeah, and that is a mandatory license. So I have to give up my patent, my exclusivity of a patent. I have to give access to it, but I can ask for money. But the money cannot be infinitive, because otherwise it would be the same as not allowing access at all. It has to be reasonable. And that definition of what a reasonable royalty is defined under the FRAND framework. And the FRAND framework is not a number. It's not like a dollar amount or a euro amount. It's a bit more vague, but I think it makes sense that it is more vague. And what does FRAND stand for? FRAND stands for F like fair. Fair has basically two elements to it. First of all, no bundling. That means a license must only include SEPs. I cannot say, let's say we go back to the Ericsson example. Ericsson cannot say, you can get access to my 5G patents, but you also need to get access to my other application patents that have nothing to do with 5G, right? That means they would create like a bundle of a license, and they would include patents that have nothing to do with the standard. That will be illegal, right? If you license the patents for 5G, you must offer a license that allows you to only get patents for a particular standard. Also, the patent owner cannot ask for so-called free grant backs. There was a case a couple of years ago between Samsung and Apple. Samsung, just to give you an understanding, is a company that has been working in standards development for many years, and they own a lot of standard essential patents. Apple, not so much, at least back then, not so much. And you remember the big fight between Apple and Samsung about design patents, Apple's design patents, because Samsung was infringing those design patents. So what Samsung had in mind was, hey, Apple, you get access to my LTE 4G patents, because Samsung has to make those patents available, mandatory license under FRAND. But you only get access to those patents if you, in return, give me access to your design patents, so we can even out that dispute we have that our Galaxy Tab looks very similar to your iPad. That is illegal, right? Samsung had to offer those 4G patents, no matter if Apple gave them access to their own patents. Only if these are, again, standard essential. But you cannot get free access to the other parties' patents, and that's not impossible. Of course, you can make gentleman agreements. We call them cross licensing. Apple can agree to a deal where Samsung gets access to design patents in return, but they don't have to, right? So that is fair. The license must be fair. Reasonable, and that's the most difficult part about it, is how much, right? How much do I have to pay to get access to those patents? And it's very hard to answer that. And there's a lot of litigation, a lot of disputes about what is a reasonable rate. And it typically breaks down to a license, right? How much dollars we have to pay per year to use your 4G, 5G patents, right? Some calculated as a percentage of the final product's price. Others do it on a lump sum level. Some have fixed fees. So there's different models to calculating this, but as said, it's the most difficult part here. And last but not least, the final part is the non-discriminatory term, meaning you have to treat all licensees equal. So even though Samsung and Apple might be competitors, Samsung has to offer the same license to Apple as they would do, for example, offer to their suppliers, right? They cannot make a difference here. So it has to be the same. And that's really what FRAND stands for. So just to sum up, standard essential patents are those patents that are, infringed when using a standard like 5G. Another example is Wi-Fi, Bluetooth, RFID, MP3. All of those technologies are standards, and they're highly patented. But those patents, you can get access to those patents. Patent holders must grant access under FRAND, and using that framework to do that. Great. Is there a question? Yeah, and a comment. Yeah. So let's have a look at companies' SEP filing and prosecution practices. I give you an example of the practice of very experienced standard essential patent owners, right? It's not everyone does it that way, but that's a very strategic way, making sure the patents you file read on the standard. Why do you want to do this as a company? Because it's a very lucrative market. You know, think only about 5G and all the different implementation of 5G. If all of these implementers have to pay in the end a license to the owner, it can be a million or billion-dollar market. We did see this from 3G and 4G already, that the big standard essential patent owners like the Ericssons, Nokias, the Qualcomms, the InterDigitals, they made a lot of revenue from those patents, and there's a high interest in getting a lot of standard essential patents. How do you do that? What could be a way to do that? First of all, I want you to understand how standards development works in a bit. And standards development is a process that is a continuous process, right? Thinking again about 5G, 5G wasn't developed and we have 5G and the work is done. 5G, for example, they started developing in the end of 2015. How does it work? Companies, for developing a standard, typically all market participants come together in meetings. For 5G, it's the 3GPP is a group, a standard group. And the 3GPP that develops 5G, they meet 8 to 10 times per year. Nowadays, it's all virtual. Typically, it's a conference style around the world, happens in Tokyo, happens in Los Angeles, in New York, in Berlin, in Paris, in Shanghai, in Seoul, everywhere around the world, they have these standards meetings. Participants are the companies in the market, the Samsungs, the LGs, the Panasonics, the Qualcomms, the Intels, the Huaweis, the ZTEs, the Ericssons, the Nokias, all of these companies, they come together in a conference. And then different engineers and experts present so-called contributions, meaning parts of technology they want to integrate in the latest version of 5G. And 5G, they started that, as I said, late 2015. Also, that one is continuously developed further. So it's not that we have the final 5G standard now, 5G is developing. And because constantly companies are submitting or presenting the latest technology to be integrated into a standard, also we have continuous numbers of patents that are reading on the standard, so-called standard essential patents. So the stack of patents is increasing as the technology is advancing, right? So we have more and more standard essential patents. How does prosecution work, and how can prosecution be aligned strategically to the standards development? So think about a corporation. In a corporation, you have different departments. And as any invention, it starts with the R&D department. That R&D department has a new invention. Again, let's say it's a new invention in 5G, right? And that new invention is disclosed internally, obviously, because we don't want to make that invention public to remain the prior art with the owner. So typically R&D departments have to report if they have a great invention that could potentially become a patent. So there's an internal disclosure of that invention. Then you have a department, which is typically the IP, or the corporate IP department, or the IP management team. That department has a so-called patent review board. So they get presented new inventions from R&D, and they decide if those inventions are, good enough to be patented, or the inventive staff. There's even an inventive step to allow filing a patent, or it's a novel idea. These kind of things are decided by the patent review board. And if they should decide, yeah, that invention is actually great, there's an inventive step, it seems novel, we should go for it, then they file a first provisional or a first priority patent with the office of, the one they decide to go for. In parallel, if the invention is subject to a, standard relevant technology, in this case, again, we keep the example of 5G. Let's say it's a 5G invention. Then once the IP review board decided we want to patent it, and they actually filed the first provisional with the office, the company is sure that they own, or that they at least have priority for that invention. because it's with the office, and they get the stamp, and once you have the stamp, you can go public. And public in this case means we go to the standards meetings, the ones I was just talking about, and we submit the technology as a proposal to become part of the actual 5G standard, right? There's a whole voting procedure within the standards bodies who can vote, like basically the members vote on those inventions that become the standard and those who don't. And that process starts then in parallel. Finally, you have in the standards development process a final version of a standard. Also here, we typically have versions, and then the versions upgrade. And again, that is also continuous. And once you have the final first version of the standard, what you can do is you can look at your invention, the one you sent to the patent office, and look at how you can basically chart or map elements of your invention to the first standard version. However, filing a patent also is a continuous process. So only because you submitted your first provisional or priority application doesn't mean you cannot change it over time. So claims in particular can be amended, or you can work with a first provisional or priority patent, and you add divisionals to it. All strategies in the prosecution process to somehow change the claims or get divisionals on your first invention. Why would you want to do that? Because standards development also is continuous and changing. So the 5G standard you first had in mind may also change a bit over time. So what you want to do is you want to amend your claims, or you want to have divisionals that now can still be charted on the latest version of the standard, right? So basically you look at standards development and strategically align your prosecution process so that your patent, in the best case, in the very end, reads on the final standard. And that's, when you get your patent granted at the particular office, and then you chart your patent or you map your patent to the final standard, and then you have actual claims that you can map to different sections of the standard, you have your standard essential patent. Once you have that standard essential patent, you can go out and license it, right? Go to anyone who implements the standard, and you can ask for money, right? And that's the great part for the patent owners of SEPs. The infringement, is basically not a question if you have convincing claim charts, because if the company implements the standard, they implement the standard. Obviously, it's not always that simple, but simplify that situation. It's like this. If the potential implementer of the 5G standard is not willing to that license, of course, we do see litigation cases. Right now, just recently, a huge litigation in the news, which is a litigation of Ericsson and Samsung worldwide. They are now negotiating on license on the 4G, 5G technology, standard essential patent technology. But you can also, of course, think about selling your standard essential patent. Some companies they don't want to. They don't want to basically commercialize those patents themselves, so they sell those patents to often so-called patent assertion entities or other market players that enter the market. So what we, for example, did see a lot is that a lot of Chinese companies entered the market in the recent years. Those companies, the new smartphone developers, they didn't have a big portfolio themselves. Think about the Xiaomis, Oppos, Vivos of this world, and they acquired a lot of patents from the other patent holders that have been part of standards development for many years before. There's the question: are claims on the drafting chart already legally protected? So once the claim charting is something that companies do privately within their corporation. Your patent, once granted at the office, is when it legally protects your invention. And that is a formal process, and that is also made public, right? I can look into the patent office database and see there are patents granted And those granted patents, I'm sure the office has granted those. If those read on a standard, is typically information that only the patent owner has, which is one of the things that we address with IPlytics. There's another question about what are the dimensions, factors of the evaluation criteria of judging if a possible patent is good enough in the patent review. Well, it's a good question. I cannot 100% answer that, but typically the dimensions or factors are the basic ones. Is it an inventive step, and is it novel? Otherwise you cannot file a patent at an office, obviously. However, of course, even though there is an invention that might be novel and that might be an inventive step, it might have the inventive step. Of course, for every company, the major question is, how is it commercially relevant? Is it protecting one of my current products or future products? Is it protecting an avenue of technology that I want to enter? Or in our case here, has it potentially be a standard essential patent? So it's like in any company, a very commercial decision about strategically protecting either your competitive space or about commercializing that patent, especially when it's a standard essential patent. How do competitors and other market players find commercially relevant SEPs if they enter the market? That's a good question. It's not very transparent. So if someone enters the market, it's not so easy to say, hi, these are all standard essential patents, you have to now license in. Typically, companies first enter the market and then the licensing comes, right? So you enter a market with your smartphone and you don't have any license for any patent, you just sell your product. And then patent owners come to you typically, or you approach them, of course, but typically the shipping of products comes first and the licensing and also the payment comes second. Just to give you an example, the auto industry, you probably heard about the litigation of Daimler and Nokia. So far, it's a litigation, right? So Daimler hasn't paid anything for 3G and 4G patents. However, if you think of Mercedes cars, Daimler cars, they've been integrating that technology since 10 years, right? So there wasn't any official payment yet of licensing terms because they are still in negotiation or in fight, to be honest. But the cars that connect to 3G, 4G are already there, right? So that is a good example to put it. So but typically, one of the things we do with IPlytics is exactly that. If you have a subscription to our tool, you have an overview of patents for 4G and 5G in the market. So if you enter that market, tools like ours provide some more transparency, even though, again, it's not as simple as that. But, just to spoil a little bit about what we do at IPlytics, part of what we do at IPlytics is making it transparent where we find standard essential patents for which standards in the market. Good question. Thanks for that. Just one side note here, because we are, this is a university lecture. So there are research papers on this. And one of the best is by Professor Knut Lind and his co-authors, Nikolaus Thürmann and Florian Berger, which is about the filing behavior of standard essential patents. And it's a great read. I recommend it for everyone to read. The main takeaways to summarize is what I just presented, what they did in their paper, they basically gave evidence to it. Because those patents that later become declared as standard essential patents have significantly more claims. These claims are amended a lot more often. The decision, meaning the grant decision, is very often delayed. And all those events of amending claims and changing or having a divisional patent on an initial application are chronological, correlated to the standard setting process. So what I presented to you was not a theory or anecdotal evidence from one of our clients or from one of our customers. It is in this paper. It has been statistically proven that standard essential patents are really filed super strategically at those offices, and I think that is a very interesting finding. Let's talk about a little bit more than just 5G. 5G is great, but let's think about a little bit about where do standards especially for connectivity matter, right? So connectivity standards and typical ones are 3G, 4G, 5G, wireless technology, Wi-Fi, but also video technologies like AVC, HVC, or VVC. Video technology, video coding technology. So if I make a video and I send it to someone of you, I of course will not send the high-res video, so it will compress that video, and you know, the whole compression and not losing quality over compression is also a standard, and those standards are typically those video coding standards. And again, I gave you other examples. We also can talk about Bluetooth. We can talk about NFC and RFID. There are a lot of standards that, you know, right? These are standardized technologies, and all of these are subject to thousands of patents. In the case of telecommunication standards or cellular standards like 3G, 4G, 5G, or wireless standards, we talk about 10,000s of patents often. In the past, that was only relevant to smartphones, right? And the whole smartphone wars, as we call it in the patent world, where a lot of times were about this. However, that changed now. Connectivity standards are more and more integrated also in other products for other industry verticals. Transportation, I was talking about cars. It is even in Europe now, you're legally bound as a company, as a car manufacturer, to integrate a technology called eCall, which is a technology when you have a crash with your car, it automatically calls the ambulance to the location of your car, and it is using 3G and 4G technology, so soon 5G, to make that available. So as a car manufacturer, you have to, if you want to ship your car in Europe, you have to have that technology, so you have to use the standard. But you know, that is just one small part. Of course, in the future, think about a fully autonomous car driving through dense traffic in a city. They can use 5G to, you know, communicate to a traffic light, to roadsides, to other cars, to pedestrians, you know, to have that live data constantly communicating with the cloud. These kind of technologies all enabled by connectivity, and that might be through 5G, that might be through Wi-Fi. Think about the whole infotainment, connecting your smartphone with infotainment through Bluetooth. Think about wireless charging of your phone within a car. Think about, you know, video coding of your display in a car. There's so many things in the automotive, but also logistics and aviation space where standards will matter a lot more in the future. And we can think about other industries like home appliances, your whole smart home, you know, smart kitchen, smart refrigerators. We can think about industrial manufacturing, the smart factories. You know, all the data that is collected in a smart factory from, you know, that machine collecting or processing and downtimes, all that has to be processed to cloud service and processed back because the cloud server runs an intelligent AI algorithm to, you know, to tell someone else to do something in a factory. All that communication back and forth, of course, again, is enabled often through standards. We can think about energies and smart meters that send constantly information about your consumption of energy, of water, of, you know, anything back to your cloud or your device. And we can even think about healthcare. You know, here that vision often is the remote surgery where the patient sits here in Berlin, but the doctor is an expert from, you know, Boston, US, and, you know, using the video coding technology to have high resolution videos of the patient here in Berlin, and using 5G or Wi-Fi to remotely, you know, somehow control a robot that is doing the surgery. So there are lots of visions, but those visions are often already reality, where standards are a fundamental technology to enable that. So also those patents reading on standards will become fundamental and for future technologies. So you are aware of that. There's again a question here. Should a car and a smart light bulb manufacturer pay the same price for SEPs? Well, I mean, that is, of course, the question of pricing is a difficult one. And I think the price should be determined by the actual patented invention where the standard matters, where the standard enables something. Obviously, the refrigerator, you know, connected to 5G, where the only thing is what you do is basically you maybe, I don't know, make a picture of your inner refrigerator to see when you're shopping what you have and what you need is very different from the fully integrated 5G in an autonomous driving car, right? And obviously then that must be of higher value and such also of a higher price compared to the refrigerator, right? So yes, it matters where the technology is implemented. And of course, also in the end, if a customer is willing to pay more, do I need the refrigerator with 5G? Maybe not. Maybe it's just a nice to have. So if it's a nice to have, I may not pay much, right? If it's fundamental to drive my autonomous car, to have it connected to 5G, well, then it must be worth a lot more, right? There's another question about Frant. Yeah, an obligation to license in the value chain. That's a very advanced question. You know, not to go into much detail here, but you can think about, you know, licensing those patents on different levels of the value chain. If you think about right now, we do see pools out there in the market that decided to only license to the OEMs, right? In the automotive space, you would only license to the Daimlers, the Volkswagens, the Audis, the Toyotas of this world, and you would not license to the suppliers, right? That's their offering. That's the way they work. In the very end, a license is an offer, right? A pool is an offer, and where that is licensed in the value chain is up to the patent owner, right? If you're a supplier and no one knocks on your door and asks for a license, you know, there's nothing else you can do, right? Then you have to wait. That creates legal uncertainty, but you know, that is often the case nowadays. But I think the next upcoming years, these things will be solved, because in the end, the patent owners need and they want royalties, and they're gonna request royalties, and we will see where it ends up. Yes, let me show you a little bit data, because IPlytics is a data company. What you see here is the data that we integrate at IPlytics. Basically, we are merging the whole world of worldwide filed patents with all available declared standard essential patents, which 5G is one database, Wi-Fi is one database. But think about other databases. As I said, wireless charging, it's a G standard, also highly patented. Think about the video coding, HEVC, BVC, VP9 standards, NFC, RFID. There's so many examples of patented standards out there. Basically the data that we pull here is from the standard setting organizations. Those patents that they publish on their websites have been declared for the patent as being standard essential. And then we also have the actual standards, you know, similar to the worldwide patent documents, we add the standards documents. And all that is combined in one intelligent platform, which is our product, the IPlytics platform. Not to talk about too much about us here, but I'll give you some statistics of the data that we pull together. Here, for example, the different generations of 3G, 4G, 5G declared standard essential patents over time. And you see, as I told you already, you know, as the technology becomes more complex and is evolving over time continuously, also the number of patents is, you know, stacking up and increasing and accumulating over time. You can also look at who are the biggest players, of course, in the market. Here we look at patent families filed at least in Europe, US, or as a PCT, meaning a worldwide application, granted versus pending patents. You see the big players are Huawei, Qualcomm, Samsung, Nokia, LG, ZTE, Ericsson, Sharp. You know, these are the top companies that own, you know, patents that they declare to be essential for 5G in the market. Interesting, you know, as we are based in Berlin, many of you are Europeans, I guess. You see, there's not so many European players anymore. We have Nokia and Ericsson, but more and more the landscape of, you know, standard essential patent owners is going towards the Asian markets, right? And we already see here in this list, Vivo and Xiaomi from China, MediaTek from Taiwan. You know, a lot of Asian players have entered the game in recent years. Back then, also in Germany, we had Bosch and Siemens owning a lot of those standard essential patents, and that has changed. And it seems like we are more in the Europe, more the users of tech technology, so the auto industry and the manufacturing industry. So, you know, you can see in a development here. But you know, I see some more questions. Can one patent be licensed to multiple companies at the same time? I think I'm confused. Yeah. It can. I mean, essential patents obviously have to be licensed to many licensees. You know, 5G is licensed to hundreds, maybe several hundreds of companies. So yes, to answer the question, there's no limit, basically. And if you think about 5G in the future, and every small device is using 5G to connect, it will be licensed to even thousands of companies. The patents are licensed through the standards. It works a bit different. Your product complies with the standard. So basically what you do is you develop the technical specifications of your product in ways that they're using the defined standardized technology. Let's say you are a startup from Berlin, you have your smartwatch and you design that smartwatch that it can communicate with the cloud through 5G. Your technical engineers have to download the 5G specification, make sure that your smartwatch complies with all those specifications, and then the base station on top of that building is able to connect with your smartwatch. That is when you use the technology, and that's when you use the patents. That is the first step. You ship your smartwatch, you go out on the market, and then, you know, you can either identify companies that own patents on 5G, or the patent owners themselves make market research, find your product complying with 5G on the market, and they knock on your door with a nice letter saying, hey, you have to pay a royalty here. So that's typically how it works. So it's one part is the technical part to be compliant to a standard. The other one is the legal, let's call it the legal part, where you have to license in those patents. Another highly patented standard, just to show you a little bit the landscape here, HEVC, AVC technologies. We have the Samsungs and the LGs up here, the Nokia's, entities, the Toshibas, the Dolbys. So also video coding or also audio coding technologies, as I said. Those are typical companies here that own a lot of standard essential patents. Let's talk about the licensing of SEPs. I think you guys had already a lot of good questions, so we covered some of the topics already, but if you think about licensing, there's mainly three things or three ways to simplify it. One is the patent owner is licensing out to the implementer. Keeping the example of that Berlin startup that is, you know, that has a product like a smartwatch. That Berlin startup has to take a license, let's say from Ericsson. So Ericsson is licensing out to that Berlin startup. But we also have a lot of situation where it's not only an implementer, it is a company that themselves own patents. So coming back to the example of Samsung and Apple, competing companies, both active in standard setting. Samsung owns 5G patents, Apple owns 5G patents. Typically what those companies do is they come together, they have to weigh their portfolios, and then they have to find a cross-license agreement because they are using each other's patents. So that is also, you know, one way. And then there is the way of a patent pool. And I want to go a little bit more into detail what a patent pool is and how it works when the patents are pooled. Just one slide. I don't want to go into much detail, but there has been a definition here on how the potential licensee and the licensor should approach each other for getting a license. Because ultimately, if someone is not accepting license terms and still using the patents, there is, you know, potential for injunctive relief. And there is here a definition of how they should behave. It goes a little bit more into the legal details, so I don't want to go into much detail here, but as I'm sharing the slides afterwards, I want you to have that in one slide. But let's talk about patent pools now. What are patent pools? Thinking about all those patents that are standard essential to a standard from all those different companies, what is the big problem here? The Berlin startup, let's take that example again. That Berlin startup has to now knock on Apple's door in the Silicon Valley. They have to now knock on Samsung's door in Seoul. They have to knock on the door of Huawei in China. They have to go to Finland and knock on Nokia's door, and to Sweden to knock on Ericsson's door. That is annoying. That is too expensive, right? No one wants to do this. All these different companies have different contracts to get access to their patents. So it's not economically feasible often to do that. So what we see in the market is the foundation of patent pools. And basically all of those company patents are put into a pool. And that pool takes over the licensing of those patents. It's basically like a service provider, right? They take all the Nokia patents, Ericsson patents, Qualcomm patents, Intel patents, Apple patents, Samsung patents, LG patents into one pool. And they manage the whole licensing. So the Berlin startup, great, only has to go to that one pool and getting access to all those patents under one single contract. That is the nice theory, right? At least what a patent pool is. If you define a patent pool in more legal terms, it is when at least two companies come together forming a joint license program. Often we have third-party administrators, companies that manage the pool. Typical ones here are, for example, MPEG-LA, Via Licensing, Sysbel, Avanci, OneBlue. There's different pools out there that have been formed. And economists, they say pools typically have a positive impact. First of all, transaction costs. I told you that already. It makes sense to have a one-shop stop. That's basically you go to one patent pool, you get your license, and you don't have to worry about it. You don't have to go to all single patent owners. That's very simple, why that is a positive effect. Then we have the multiple marginalization problem. That's a more economical theory problem, but it actually applies often. What is that? It is a situation where, let's say we have 100 essential patents, making that simple. And all companies own 10%, right? And we have 10 patent owners. That means Apple owns 10 SEPs. So logically, if you think 100% is the license, and let's say to get access to those patents, I have to pay $10 per device. So Apple should ask $1 from me, because I paid $10 for the 5G technology. Apple owns 10% is $1. Typically, what happens is it's not transparent that the overall number of 10 essential patents is 100, right? It is intransparent. So the Berlin startup doesn't know that Apple owns 10%. So what Apple says is, no, we actually own 15%, to be honest. And then Nokia says, oh yeah, we own also 15%. And then Ericsson says, oh, we even own 20%. Adding up all those numbers, you come up with suddenly, I now have licenses, but it is way beyond the shares that I thought, right? It's everyone is overestimating their share. And that's what we call or multiple marginalization problem, that if it's an intransparent market, the owners of the technology overestimate their share, which makes the licensee pay too much. And that's a problem. It's inefficient. It creates problems. It creates friction in the market. Worst case, we have litigation. Having one pool where it's very transparent, all patents in the pool is all patents on the market. 100 patents, Apple owns 10, they get 10%. As simple as that, at least in theory. We also have no blocking positions. So having all patent owners aligned in one contract, we don't have any legal risk that someone goes to litigation or blocks the implementation. And since all that is so simple, we, in theory, facilitate the use of the technology. And we do have good examples here. MP3 was a great, even had two pools here, but it was a great example of a successful pool. DVD, MPEG pools, even some of the video coding pools. But we also have examples where pools didn't work that well. We do have another question here. Why are firms not required to show that they have licensing contract prior to the launch of their products? It's a good question. Why it isn't the case. One of the reasons is, again, it's a continuous process, meaning, again, the Berlin startup using 5G today, the Berlin startup may use a version of 5G today that in 1 year's time is the updated 5G version, and it may include further patents. So it's not as easy as we have that final standard, here we go, you need a license before you ship your products. Also, because licensing negotiations take a lot of time, it wouldn't be economically feasible. Again, the example of Daimler and Nokia, those guys are negotiating on a license price since, I heard, at least 10 years. So let's say if Daimler could only, ship their Mercedes cars that are connected to 4G when they have the final approval of contracts, we would hold back on our innovation for years, right? And we wouldn't have connected cars just because Daimler couldn't get an agreement with Nokia. And it would also, that is probably, I guess, one of those reasons. Another question here is, who decides what is a patent and what is an SEP? It is, in the end, a court who can only decide what a standard essential patent is. Of course, you can come to an agreement if two parties meet and one party says, yeah, I acknowledge your standard essential patents, but officially it has to be a court where the court says this patent is describing a claim that is infringing on any implementation of the standard. Unfortunately, that is the case. Yeah, so patent pools would be great because patent pools also patent pools can decide or have an external objective analysis of what is a standard essential patent. And also that would be good. However, pools are not always successful. First of all, it is quite expensive to set up a pool because you have to have an administrator who gets all the patent holders together, negotiating one contract where all the patent holders are happy with. It is quite difficult, I can tell you. The one reason is the revenue sharing rule. Even if you only have, let's say, 100 5G patents, and even if Apple has 10%, Ericsson has 10%, Samsung has 10%, companies may argue, hey, you cannot just count patents. My patents are more valuable. And it's true. Inventions are sometimes disruptive, and one patent can be super valuable. Others are niche patents no one cares about. So also within the standard, you have more, you have inventions that are patented that are more basic and fundamental to the standard, while other inventions are more edge, cases, protecting something on the edge. But who's to say what is a valuable patent to a less valuable patent, right? So it is very complex to set up those pools. And that's also why a lot of times pool administrators try to set up pools hasn't worked in reality. And also, there are reasons for companies to stay out of a pool, right? Because they have, for example, a very efficient licensing team, or they want to, they like that there is a pool, but they want to stay outside of the pool to maybe ask for a higher price. So there's all those strategic momentum in here where the patent owners feel like they are better off not joining a pool. Right? And in the end, it's a chicken and egg problem. If no one joins the pool, no one wants to join. Who's going to join a pool without members, right? So who's the first to join? Who's the first to commit? All that, these are difficult things. If you look historically, I know it's old data here, but back then when I was still at university, we looked at pool launches in the past, and we looked at successful ones here in blue, and non-successful ones. And you see that for the audio coding, MP3, for the DVD video coding, we had highly successful pools, while a lot of times in the cellular technology space, that hasn't worked out so well. So there are positive and negative examples for pools. So for some technology, it works, for others, it doesn't, and the reasons I just gave you. And another statistic, again, a little bit outdated, that basically shows even if you have a patent pool, not all patent owners might be members. So you may have always outsiders. So parts of the patents you get through a pool, while the other parts of the patents you have to still individually go to each and every patent owner. And I give you some real world examples. This is the Avanci pool. And Avanci licenses standard essential patents for the use in cars. And they license 3G, 4G, and they now also have a 5G program. And you see, if you look at the Avanci members, it's almost 50-50. Some companies joined Avanci and licensed all their 3G, 4G, 5G patents to the car manufacturers. But there are companies that remain outsiders, right? And they didn't want to join Avanci. And they also have a substantial share of the total number of patents. Again, those numbers that I show here may not be accurate 100%, but what we've seen, at least when we created those graphs, that maybe 50% is covered by Avanci. I think Avanci on their website, they claim they have a higher percentage, which could be true. We have other situations. Look at HEVC, which is a high efficiency video codecs. And here we even have 3 patent pools. Again, quite complex situation. So and outsiders. So you basically have to go to 3 different patent pools and 2 companies that remain outside of the pool to get access to patents on video coding. There's a question here. Are these patent pools fair in terms of money to be paid for more or less expensive devices? No, it depends. But if you think about Avanci, the license for the cars, and I go back here, they have their dollar prices on the website. It is per car, it's per vehicle. So let's say you want, the last deal here, $15 per vehicle. It's the same price for your small Fiat 500 as your Ferrari. It doesn't matter how expensive the car is for that particular case. There might be other cases where it's different, but in patent pools, what I've seen, it's per device typically, no matter if it's an expensive one or more or less expensive one. So just so you are aware, it is very typically per device. Again, I'm sure if Avanci comes up with a licensing program for refrigerators, I'm very sure it will be cheaper to have patents, to have SEPs for your refrigerator. That's just my assumption. But within one category of products like cars, there's no difference. However, here coming back about patent pools in the video coding space, as to our estimation, there's a lot higher share of patents pooled for HEVC, so it's almost over 70%, and those 3 pools share different percentages of those pools. So you see, it's complex. Pools may reduce the number of patent holders where you have to get a license from, but they may not 100% have all patents included. Due to there's not much time left, I'll rush a little bit through those industry anecdotes, but I think there are some great stories that I want to share with you. Google entered the smartphone market, acquiring the operating system Android, right? Many of people do not know that, but Android was a startup that Google acquired. And which was the foundation of their online operating system, right? In 2009, Google owned about 170 patent families, compared to a company like Microsoft, who owned over 8,000 patent families, right? So Google, in terms of patent ownership, was a no one, right? Google was nothing. In 2010, Microsoft generated more revenue from patent royalties from Google's Android than through their own mobile operating system. So that's a funny story. Android was so popular, was used in so many smart devices, that Microsoft, who owned patent that Google infringed with Android, got more revenue than with shipping their own operating system, right? So there was, back then, an operating system, I think it was mainly run on Blackberries, from Microsoft. But that wasn't really successful. So the actual revenue they made with mobile operating systems came through their patents on the Android technology. And apparently Google infringed those patents. Google wasn't aware that they were infringing so many Microsoft patents. So it was really hard for them to pay all that money back to Microsoft, because they thought their Android system, which is open source, is not covering too many patents, but it is open source and it did touch Microsoft patents. Why is that story interesting? Because it's the beginning of a fight between Google and Microsoft and other companies. Why is that? Microsoft, basically Google realized, we are a search engine company. but we're entering a new market now. With Android, we are entering the smartphone market, and that market works a bit differently. Here, patents are basically weapons to fight about, market share. So, Microsoft basically showed us that, they're not happy with our Android kicking out their Microsoft operating system out of the market. So they're fighting back with patents. So Google needed patents. And there was a coincidence. There was Nortel, a company that got bankrupt. And Nortel was for sale. And Nortel has a patent portfolio that is quite valuable. So it was an open bidding. It was, in a sense, open that you knew who was going to bid, but the amount was not disclosed. So Google started the bidding, and they, we know that now, but back then it wasn't disclosed. They went for 900 million, and they only wanted the Nortel patents. They were not interested in the business. And that is when Microsoft heard, oh wow, Google, they want to acquire patents. And they looked at the Nortel portfolio, and Microsoft realized there were a lot of standard essential patents in that portfolio, and Microsoft was infringing a lot of those patents. So Google would have the ability to fight back. So what Microsoft did, they went to other companies that were a little bit pissed off because Google had this great Android operating system, like Apple, like Sony, like BlackBerry. And they formed a consortium, which has then been known as the Rockstar Consortium. And they also, entered the bidding of the Nortel patent portfolio, and they offered 4.5 billion, right? So, a lot more, or 5 times more of what actually Google offered. And obviously that consortium that won the bid. So the Nortel patents went to that consortium of Apple, Microsoft, Sony, and BlackBerry. Interestingly here is that the bankruptcy managers offered patent portfolio and business, or both. And Ericsson was the only company that was bidding for both, the business and the patents, which is really interesting, showing how separate it can be, that a lot of companies were really not interested in the business. They were really only interested in the patents because they were like so strategically relevant. Well, since Google lost that bid, they had to do something else. Motorola wasn't bankrupt yet, but they didn't do very well. And their stock market price was really, really low. So what Google did is they acquired Motorola Mobility for 12.5 billion, which was 63% over the market capitalization. And again, Google wasn't really interested in the business. First, some people thought, oh, wow, Google is entering the market now for smartphones, but they weren't. They were only interested in the patents. And you can see that later because they, again, sold the Motorola business separately from the patents to Lenovo. What happened afterwards, since Google owned Motorola, in particular the Motorola patents, which were a lot of standard essential patents in the cellular space and the wireless space, meaning Wi-Fi and 3G and 4G technologies, they directly went after Microsoft. Microsoft is using Wi-Fi patents in their Xbox device, and they were asking for high royalties. Here, for example, $4.48, while the chip, the main intelligence of the Xbox, was worth only $3 to $4. They asked more than the chip. And they asked also more for other technologies like the video coding technologies than some patent pools, right? And from then on, a lot of disputes in court, Motorola, which was actually now Google, fighting Microsoft around standard essential patents. And there was a lot of litigation going on because really Google was fighting that. In general, there are even today a lot of disputes around standard essential patents. I don't want to go into much detail. What is interesting in the last 2 years, especially here in Germany, those litigations were dominated by the automotive industry. Nokia, Daimler, Nokia Continental, Broadcom, Daimler, Broadcom, BMW, Sharp against Tesla, Syswell against Tesla, Coversand against Daimler, and Coversand against Tesla. So a lot of litigation going on around standard essential patents. I do see some more questions. Does Avanci distinguish between different levels of autonomously driving cars? No, they don't differentiate at all. And they just license out 4G or 3G, 4G, soon 5G, no matter what the automotive manufacturer makes with the technology, right? They just, once they have it comply to 5G, even if it's the simplest, stupid application, that's when they have to pay, no matter what they do with it. Yeah, I do have a few more minutes, but I have to wrap up soon. There's a question if we do have more cases. But as I said, I will for sure share the slides afterwards, so you can read through those. Another question here, how about the car end manufacturer? They no margin to pay. Right, yeah, I mean, that's always the argument. There's no margin on selling the cars, which I'm not an expert in the auto industry. But what I found funny is that, I mean, typically you could say, well, it's not the auto industry that has to pay it. If everyone has to pay for SEPs, then just make your cars $15 more expensive. $15 is what? A car wash, right? That's what one example I heard once. However, I'm not the judge here. I know that auto industry has margins that are super small. And to me, it really matters on how the technology is used in the car to determine what a fair price is. Right now, it's $15, but it's also $15 for only maybe 50% of the patents. You have to be aware of that. Yes, and also litigation, a lot of litigation around wireless and cellular technology. There's some papers around it. By the way, in the slides, I always quote the papers here as source. So if you're interested in reading those, you find those in the slides. A lot of litigation is around where the plaintiff is actually very often an assertion, patent assertion company. Some people call them patent trolls. So that also happens a lot in standard essential patents, that those large SEP owners at some point just sell their patents and other people are commercializing those patents, just so you are aware. Yes, to wrap up this lecture, as I unfortunately have to wrap up now, and I cannot also cannot answer many more questions, but I think there are a lot of challenges for licensing standard essential patents in the future. A lot of those can be solved with more transparency. That's what we do at IPlytics. We have a software tool where we allow and give access to which patents are part of a pool, who owns those patents, who sold those patents, maybe to a patent troll. All that information we provide. But of course, there will be also needed more understanding of how and how to license those patents, if it is a license only to OEMs or to different tiers of suppliers. I hope there will be more patent pools. Patent pools typically are good for transparency, and they can resolve certain disputes, but it will be a challenge. And right now, there's no solution. You have, Alexa connected to Wi-Fi, and it might not be licensed yet. You have that smart startup watch connected to 5G, but they don't pay a license yet. So a lot of technology out there is already there. It works, and it works perfectly, and it's all connected. Your refrigerator is already connected, your smart home, your security, it's all connected today, but no one is paying a license. So there has to be a solution in the future soon to solve that issue, to decrease legal risk, and to increase the implementation of that great technology. Again, if you do have questions, I also have in the slides my email. It's Pohlmann at IPlytics.com, my last name at IPlytics.com. Shoot me a message, happy to answer that. Thanks for having me, guys. And yeah, you have a great evening if you are in Germany. If you're located somewhere else, you have a great night or day. Again, thanks for having me, and goodbye.